Elective course Ethics and Medical Jurisprudence, second BHMS professional course CBDC, Module 4 Indian Medical Jurisprudence. This is lecture 1 regarding Introduction to Medical Jurisprudence. Myself speaker Dr. Ragini Raut, MD Homeopath, HOD, Associate Professor, Department of Forensic Medicine and Toxicology, Bharati Vidyapeeth, Homeopathic Medical College, Pune. This is lecture 1 regarding Introduction to Medical Jurisprudence. There are 4 components of this lecture: definition and scope of medical jurisprudence, historical evolution in India, key legal frameworks governing the medical practice in India, and role of forensic medicine. Introduction to medical jurisprudence, definition and scope of medical jurisprudence. Medical jurisprudence, in Latin, juris is law and prudentia is knowledge, known as medical law of legal medicine. It is a branch of science which deals with application of medical knowledge to legal issues. It mainly deals with legal aspects of practice of medicine. It includes responsibility of doctor and deals particularly with the doctor-patient relationship, medical relationship, medical and duties of doctors, professional doctors and professional ethics, etc. It is also termed as state medicine. Scope of medical jurisprudence. The scope is forensic medicine examine the injuries, deaths, diseases to aid in criminal investigation and proceedings. Second, it is medical ethics addressing moral principles and values in medical practice, research and patient's care. Third is medical negligence, investigating allied malpractice, breach of duty and standard care. Fourth is medical evidence, interpreting medical records, testifying in court and providing expert opinions. Fifth is healthcare law, regulating medical participation, rights and healthcare policies. Sixth is toxicology, analyzing the effect of substance on human body in criminal and civil cases. Seventh scope of medical jurisprudence is mental health law, dealing with issues related to mental capacity, consent and criminal responsibility. Eighth is medical research law, regulating ethical conduct, informed consent and data protection. Ninth is public health law, addressing the legal issues related to disease prevention and control and health promotions. Tenth is bioethics, examine the ethical implications of medical advancement and its technologies. 11th is, hence the scope of medical jurisprudence is vast and constantly evolving, influencing the healthcare delivery, legal proceedings and public policy. Historical evolution in India is medicine and law were inseparable from time and origin of human communities and civilization. Medical problems are found written in the records of civilizations, medico-legal and India. China Materia Medica was written in about 3000 BC, gives information on drugs and poisons. The Code of Humanity by the King of Bainor is considered to be the oldest medico-legal code. Chinese law were prevalent from 400 BC. Egyptian laws were prevalent from 3000 BC, knew the art of mummification, in whom was the chief justice and physician to Pharaoh's resort, and he can be considered as a first medico-legal expert. Historical evolution in India. Jewish laws and Greek laws were prevalent from 1200 BC. Socrates 417–399 BC, great philosopher and social informer in Athens, was executed on the crime of misleading the young generations of Greece by poisoning the hemlock. Hippocrates has contributed to the code of medical ethics. He is considered the father of the modern medicine. Roman laws were prevalent from 15th century BC. Julius Caesar was born by the Caesarean section. Julius Caesar was assigned by his Senate members in the 1st century BC as assistants, and the physician of the palace examined his dead body without opening the palace. Examined recorded that were 23 stab wounds on the Caesar's body and only one that entered the chest between the first and second rib, which was fatal. That was the first post-mortem report on the dead body without opening it. Next is historical evolution in India. Manu Samhita was composed around BC and Manusmriti was written in the 1st century. Manusmriti, the law in India while ruled by the kings. Manu can be considered the father and the legal medicine in ancient India. Manusmriti describes collection of evidence and conduct of trials. It describes the nature of the crime like trials, etc. and punishments for such crimes. Vedas were written between 2000 to 1000 BCE. Vedas wherein mention of crimes like BCE and prescription of punishment of their acts. Next is, in India, forensic medicine has attained its present state of development by passing through several phases of evolution amidst superstition, religion, magic through the centuries and subsequently imbibing Western concepts under the British regime. In ancient times, no person was safe from the attacks on himself or his property, and the tooth for the tooth, on the eye for the eye, and the life for life was the rule of law. In the history of medicine, Manu, that is 3002 BC, in his famous treatise, Manusmriti prescribed various rules relating to minimum age of marriage, punishment for offences like sexual offences, and as to how a disease or intoxication could render one capable of making contract or to dispose in the court. During the Vedic age 2000 to 1000 BC, Rig Veda were written which mentions about how the physician successfully cures patients literally on the verge of the death. Similarly, other Vedas mention crimes such as adultery, incest, abortion, murder and prescribe punishments for the same. History of forensic medicine. In Atharva Veda, there is a mention of cures of injuries due to arrow, stab wounds and snake bite, etc. Criminal abortion, bronchitis and suicide, tahmata, were specially mentioned as punishable under the law in the Vedas. Even the nature of the poison was attempted to be detected from the nature of the flame and sound of fire when the stomach or heart were diseased, dead due to the poisoning was put in the state. Also during the period, it was stipulated that no one could practice medicine without a permission of the king, denoting a kind of medical registration system that we have now. Also physicians were held responsible for negligence and carelessness in their statement or in the treatment. History of forensic medicine post Vedic period. There is a Buddha era. King Ashoka established hospitals and roadside clinics and teaching period system of medicine was introduced. 4th and 3rd century BC, that is Mauryan Empire period, Kaurtritya, the art of Shastra was written. During the periods, it is said to be the best treatise ever written in India on the medico legal investigation of crimes, administration of law and justice. Kautilya advised medical examination in case of death due to advice and asphyxia, similar to the post-mortem examination conducted today. History of forensic medicine, that is AD 200 to 300 in the Sushruta Samhita, compiled by Sushruta, father of Indian surgery, dealt not only with the management of surgical cases, but also detailed the good qualities of an ideal physician. Charak Samhita mentions about training and duties for chakra were classified, as well as treatment measures for poisoning were mentioned. The king was warned about poisoning effect on contact with Vishalkanya. Charak, the father of Indian medicine, also laid down guidelines as to how a student should be trained to become a physician. Hence, he is also known as the father of state medicine. The physicians of those days were held in high esteem both by the king and by the general public. History of medicine in AD 1000 to 1600, this period witnessed the invasion of India by foreign powers such as Turkeys, Pathans and Mughals. They became the plunder, spread religion and to rule the land. There were no improvements in teaching or training of the physicians. Their law was based on the Quran, Hadith and Sara. Jurisprudence was based on Sharia's rules, which included punishments like cutting of the body parts, execution by trampling under elephants' feet, throwing to the wild animals, etc. Unani system of medicine as introduced during this period. Self-immolation practice, that is sati, was practiced widely by Hindu females. History of forensic medicine at 16th and 19th centuries, the Portuguese, Dutch and French came and settled down and ruled the country. Later, the English East India Company was established and the British conquered the country, thereby introducing a whole new system of medicine and legal procedures. Coroner system was introduced in Calcutta and Mumbai by Coroner's Act 1871. However, the rest of the country followed the police system. The first medical college in the country was started in 1835 in Kolkata. Similar colleges were later set up in Chennai and Mumbai. History of forensic medicine at the present day. After 1947, many amendments were made to the above mentioned acts. Medical jurisprudence changed its nomenclature and forensic medicine. Dr. Jai Singh P. Modi became the first Indian physician to handle the cases of medico legal nature. Among the early forensic medicine experts of India, two professors who contributed extensively the growth of the specialty include Professor Bhushana Rao and Professor A.T.S. Iyengar. Forensic medicine together with the toxicology is now the part of medical curriculum in all universities throughout the country. Graduate medical education 1997. The specialty is expected to the further strengthened after the release of the new MBBS curriculum, graduate medical education by 2018 by the Medical Council of India. The entire field of forensic science has developed by leaps and bounds over the last few decades. In India, every state and country has well equipped forensic science labs, many of them with the advanced biotechnology divisions attached that undertake forensic DNA analysis. The first laboratory exclusively dedicated to DNA analysis in criminal cases was the Center for DNA Fingerprinting and Diagnosis, CBDFD, which was established in 1995 by the Lalji Singh, the pioneer of forensic DNA typing in India. The field of medical toxicology has received a boost with the establishment of poison control centers, one of which is set up by V.V. Pillai in 2003 as Amrita Institute of Medical Science, that is AIIMS, in Cochin, Kerala, in the most fledged center and state of the art poison information and analytical services. For an overview of historical evolution of the specialties of forensic medicine and toxicology in a pictorial manner comprising images of the stalwarts who helped shape these two fascinating branches of medicine arranged in the chronological order, every medical worker is invited to visit the corridor of fame established in the Department of Forensic Medicine and Toxicology at the AIIMS, Cochin, Kerala. The second aspect is the key legal frameworks governing the medical practice in India. These are governed by Indian Medical Council Act 1956, that is IMC Act. The Act in 1933 was repealed and the Act of 56 was passed. This Act was further modified in 1964, 1993 and 2001. In 2010, MCA Amendment Act 2010 was approved by President of India, superseding the previous council. It regulates the medical education, training and registration, set the standards of medical education, ethics and practice, outlines the code of conduct, ethics and professional behavior for the physicians. In 2018, the President of India dissolved the MCI and appointed 7th member of committee comprising of medical expert to perform functioning of the council till the bill which seeks to replace the body with a new National Medical Commission was passed in the parliament, that is NMC. Why the MCI changed to NMC? To bring reforms the medical education sector, especially aimed at replacing the MCI which was strained by corruption and with the problems. It functioned from 25th September 2020. Key legal frameworks governing the medical practice in India comes under National Medical Commission 2019. Its functions are: lay down the policies for maintaining the high quality and high standards in medical education and make necessary regulations in behalf. Second is lay down the policies for regulating medical institutions, medical researchers and medical professionals and make necessary regulations in this behalf. Next is assess the requirements in the healthcare, including the human resources for health and healthcare infrastructure, and develop a roadmap for meeting such requirements. The next is promote, coordinate and frame guidelines and lay down policies by making necessary regulations for the proper functioning of commission the autonomous boards and the state medical council. E is ensure the coordination among the autonomous boards. F is take such members as many necessary as to ensure the compliance by the state medical councils or guideline the framed and the regulations made under Act for their effective functioning under this Act. Exercise applicate jurisdictions with respect to the decisions of autonomous boards. H is lay down policies and codes to ensure, observe and professional ethics in medical profession and to promote ethical conduct during the provision of care by medical practitioners. Frame guidelines to determination of fees and all other charges in respect to 50% of seats in private medical institutions and deemed to be universities which are governed under the provision of this Act. Exercise such other powers and perform such other functions as may be prescribed. In the key legal frameworks governing medical practice in India, Clinical Establishment and Regulation Act 2010, it regulates the clinical establishment including hospital, clinics and diagnostic centers. Functions are compile, publish a national register of clinical establishment within 2 years from the date of commencement of this Act. Classify the clinical establishments into different categories, and third is develop the minimum standards of their periodic review. Other functions are determine with a period of 2 years from its establishment the first set of standards of ensuring the proper health care by clinical establishments, collect the statistics in respect of clinical establishment, perform any other function determined by the central government from time to time. Drug and Cosmetic Act 1940, it regulates the import, manufacture, sale or distribution of drugs, cosmetics through licenses and permits. Its main objective is to ensure that the drug and the cosmetics marketed in India are reliable, efficient and in the compliance with national standards. The Pharmacy Act 1948 objective is Pharmacy Council of India, its constitution and functions, education and regulations, state and joint state pharmacy councils, constitutions and functions, registration of pharmacists, offences and penalties. The Narcotic Drugs and Psychotropic Substances Act 1985, its objectives are to amend the consolidate the laws governing the use and possession of narcotic drugs, to establish stringent provisions for the control, regulation and supervision of the illegal possession, sale, transit, consumption of narcotic drugs and psychotropic drug substances, to provide a mechanism of forgetting narcotic drugs, psychotropic substances as well as properties derived from or use or illicit drug trafficking, to establish a mechanism for the implementation of provision of internal convention on narcotic drugs and psychotropic substances as well as for the purposes of connected therewith. The Mental Care Act 2017 Advance Directives, a mentally ill person shall have the right to make the advance directives that states how it wants to be treated for the illness during the mental health situation and who is nominated respective shall be. The advice directory has to certified by a medical practitioner or registered with the mental health board. If a mental health professional, relative, caregiver does not wish to follow the directives while treating the person, he can make an application to the mental health board to review, alter, cancel the advance directives. The Transplantation of Human Organs and Tissue Act 1994. It was amended in 2011 and again re-amended in 2012. Transplantation of Human Organ and Tissue Rules 2013. The Act provides the regulation, storage, transportation of human organs and tissues for therapeutic purposes, for the prevention of commercial dealings in the human organs. It has 7 chapters. Chapter 1 and 2 deals with definition, authorization for removal, storage and transplantation of human organs or tissues. Chapter 3 deals with regulation of hospitals conducting the removal, storage or transplantation of human organ. Chapter 4 and 5 deals with authorization of the committee or committee which shall be constituted by the state government, and 6 and 7 deals with the trial and punishment of offence under this Act. No human organ or tissue or both shall be taken from minor or mentally challenged person. Consumer Protection Act 1986, that is also called as a CPA, it was amended 1991, re-amended 1993 and lastly 2002. The aim of this is it protects the interest of consumer and providers for establishment of consumer councils or forums for its purpose. The district, state and national commission have been established with looks into the complaints of the consumer. They provide speedy and simple solutions to consumer disputes. This is a quasi judicial body, observes the principle of natural justice and are empowered to give the reliefs and award appropriate compensation to the consumers. Roles of doctor under various laws. First is Indian Penal Code, that is Bharatiya Nyaya Sanhita 2023. Second is Criminal Procedure Code, that is Bharatiya Nagrik Suraksha Sanhita 2023 and Indian Evidence Act Bharatiya Sakhya Adhyayan 2023. These laws were implemented from 1st July. In Indian Penal Code, that is Bharatiya Nyaya Sanhita 2023, it deals with the criminal laws in India. It describes the offence and their punishments. Criminal Procedure Code Bharatiya Nagrik Suraksha Sanhita 2023, it deals with the legal procedures in various criminal matters. Indian Evidence Act Bharatiya Sankhya Adhiniyam 2023 BSA, it deals with the laws of evidence which is applied in the judicial proceedings. Role of forensic medicine. Forensic medicine, it is defined as an application of medical knowledge for the administration of justice. A doctor acquires medical knowledge during his career and applies that knowledge in giving his opinion in various cases to solve the medico-legal problems faced by the legal authorities. The word forensic is originated from the Latin word forensic, meaning of the forum. Forensic medicine is called as legal medicine in European countries and United States. Forensic medicine plays crucial role in India, contributing to criminal investigations, death investigations and injury assessment. First is criminal investigations, providing medical expertise to investigate crimes such as homicide, suicide, accidental, sexual assault, poisoning, suspicious events and medical negligence and others. Death investigations, conducting the autopsies and examining dead bodies to determine the cause of death, time since death, identification and to know the manner and nature of death. Injury assessment, it plays a major role in evaluating the injuries to determine their nature, severity and potential causes, which include manner of infliction and number of weapons and number of assailant with their directions. Fourth is toxicology, analyzing biological samples for the drugs, poisons, chemicals and other substances. It deals with signs and symptoms, diagnosis and treatment of poisons. The toxicology is determined for the Greek word toxicon, means for poisonous substances and use the arrowheads. Definition of poison: any substance in any form entering into the living body through any route of coming in contact with the body surface that will produce ill health or death by its local or remote action. The difference between drug and poison is only on the dose, because drug is overdose may cause a poison and poison in the lower dose may be called drug. DNA profiling, assisting in identification the paternity and disputes. DNA analysis, that is DNA typing, DNA fingerprinting, DNA identification is a leap forward in the crime investigation, as it gives unique identity of the individual. The technique developed by RFLP by Alec Jaffrey, a British geneticist, in 1985 and in 1986, this method was used by him to find criminal in a case of rape and killing two girls, and Colin Pickott is the first criminal to be convicted on the basis of DNA evidence. In India, DNA evidence was first accepted in the court of law in Tandoor murder case reported in 1996 in New Delhi. RFLP means restriction fragment length polymorphism. Newer techniques, that is the STR, short tandem repeats, and PCR technique, polymerase chain reaction. Application of DNA typing in case of dispute of paternity or maternity in criminal investigations. Identification of the human remains, that is sample collected for a DNA analysis are blood, semen, bone, hair, tooth pulp, buccal epithelial cells and other tissues. Role of forensic medicine: medical negligence, investigating allegations of medical malpractice. Definition is: it is a failure to execute reasonable degree of skill and care and willful negligence of the medical practitioner which cause some harm or bodily injury or death of a patient. Negligence may be act of omission, that is not doing something that is reasonable man under the circumstances would do, or act of commission, that is doing something a reasonable man would not do. It has 4 essential ingredients, that is 4 D's: duty, deterioration, direct causation and damage. Hence, medical practitioner has a duty to treat a patient with reasonable skill and care. If it is not executing that duty, it will be amount of the negligence. Court proceedings: offering expert testimony in the court to aid the delivery of justice. The court is given by Mahatma Gandhi. There is a higher court than the court of justice, that is a court of conscience. Witness: it is a person who provides evidence about the fact in the court of law under oath and being summoned by the court. Any person can be witness unless suffering from mental illness. There is no age bar for witness. Witness are of 2 types: common witness and expert witness. Common witness: he is a person who narrates what he heard, perceived or states in the facts observed by him. He gives first hand knowledge. Example: A had seen that B is stabbing and C with the knife. Hence, A becomes common witness. Even a dumb person can become a common witness. Expert witness: he is a person who is trained, skilled in a technical or a particular scientific subject of the forensic law, art or science, and capable of forming opinion and drawing inference on the observations made by him or by others. Such persons are experts in their testimony in expert evidences, section 45 IC, section 39, 2023. Examples of expert witness: doctor, firearms expert, fingerprint expert, handwriting expert, expert in DNA analysis, chief, that is chemical examiner to the government, and serologist to the government. Doctor can give an opinion regarding the cause, manner and time of death. A firearm expert can be given opinion regarding the distance of fire, and a fingerprint expert can compare fingerprints and comment on which person it belongs. Record of evidence: evidence of the witnesses is recorded in the court as follows. First is oath taking, that is section 15 IPC, examination in the chief, that is section 177 144 IFA, then cross examination section 137 to 146 IEA, re-examination section 137 138 IEA, and court questions section 165 IEA and section 311 criminal procedure code. Now, some of these sections are overruled by BNS 23 as per the new amendments, that should be taken care of. Perjury: intentionally and giving the false evidence in the court of law by the witnesses, and while under the oath of failure to tell what he knows or believes is to be true. It is section 191 IPC and now new as section 227 BNS 2023 is called perjury. Witness liable to be prosecuted for perjury, imprisonment may extend to 7 years and also liable for fine under section 193 IPC. Hostile witness: it is the one who speaks just opposite to what he stated earlier. Leading questions are not allowed in chief examinations under section 142 IEA, and leading questions are allowed in cross examination under section 143 IEA. Both are overruled now by the section BSA 2023. Disaster response: providing mental expertise during mass disasters. The forensic medicine expert has always had a central role in the identification of the dead in everyday practice, in accidents and in the disasters involving hundreds or thousands of victims. The role has changed in the recent years as the advances in the forensic odontology, genetics, anthropology, and have improved the chances of identifying the victims beyond recognition. Providing medical expertise during the mass disasters. According to the Interpol DVI guide, fingerprints, dental examination and DNA are the primary identifiers, and this has given new emphasis to the role of forensic pathologist as a leader of a multidisciplinary team of experts in the disaster situation. It is based on his or her qualification and the experience gained from doing the same work in the everyday situation of an institute of forensic medicine. There are certain examples of role of forensic medicine in mass disaster. Mass disaster is commonly defined as the death of more than 12 victims in the single event. It is number of deaths that exceeds the capacity of his local death investigation system to handle it. These are some certain pictorial examples are mentioned here. There are certain natural disasters like earthquakes, flood, tsunami, volcano and cyclone, which most of the time many of the states have been experienced. Here comes the role of the forensic medicine. Examination of the bodies of the victims by forensic experts in the necessary for three main reasons: to identify each dead body and to establish the cause of death for legal purposes so that a death certificate can be issued. Second, to discover evidence relating to the investigations of the disaster itself, like obtaining sample for the toxicological analysis where it is appropriate. To find out the cause of the disaster itself, like bomb or detonator fragments that may be embedded in the bodies of the victims. Management of the mass disaster. Management of the mass disaster is coordination. It requires infectious disease risk, body recovery, storage of the dead bodies, identification of the dead bodies, information management, long term storage and disposal of the dead bodies, communication with the media, support to the families and the relatives. There is a further role of forensic medicine. Whether no further lives can be saved, situation should be taken under your control. Evidence should be preserved which may contribute both to their identification and to the investigation of accident itself. Adequate victim identification management goes through strict methodology and protocols. This requires adopting, applying standard operating protocols. Such a huge operation requires multidisciplinary team. The expertise in relation to disaster victim identification is enhanced when team members working together in the interdisciplinary way share mutual respect and professionally trained, skilled and have multifunctional capacities. Role of forensic medicine in India faces challenges like limited resources and infrastructure, shortage of trained professional experts, need standard protocols and SOPs, integration with law, enforcement agencies and other departments. So, we will conclude now about our first lecture, that is Introduction to Medical Jurisprudence. As we have discussed in the introduction of medical jurisprudence, there are 4 components, that is definition and scope of medical jurisprudence, historical evolution in India, then key legal frameworks and the governing medical practice in India and role of forensic medicine. All these 4 scopes include medical jurisprudence definition, its branches, its legal aspects and about the medical jurisprudence. In the next, we have included so many topics like medical ethics, medical negligence, medical evidences, healthcare laws, toxicology. Then we have discussed about the mental health laws, medical research laws, public health laws, bioethics. Then we have discussed about the historical evolution of India from its starting, that is from the medicine to Jewish era to Roman laws, then present status at is Manu Sanhita BC. Then we have discussed how it is developed in India and who are the pioneer and how the ancient era is converted into the evolution or help in the evolution in the India, that is Manu era, then during the Vedic era. Then we have considered about the adultery, incest and abortions, then Atharva Veda, Charak Sanhita, all these things we have discussed and come to a conclusion. Then we have discussed various acts like Indian Medical Council Act, then National Medical Commission, that is 2019. Then there are certain Clinical Establishment Regulations Act 2010, then Drugs and Cosmetic Act 1940, Pharmacy Act, then Narcotic and Psychotropic Substances Act, Mental Health Care Act, then Transplantation of Human Organs and Tissues Act, Consumer Protection Act, and how it is changed from the new Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha and Bharatiya Suraksha Adhiniyam. These were replaced as were discussed from the 1st July 2024. Then what are the dealings of this act done under? We have discussed about that also. The some are deals with the criminal laws, some are deals with the legal procedures and some are deals with the evidence applied to the judicial proceedings. Then we have discussed about the definition of the forensic medicine. Then in this definition we have discussed criminal investigations, death investigation, injury, assault, toxicology, definition of poison, how the poison can become drug substances and how it is utilized. Then DNA profiling, how it is helpful. Then what is the application and implementation of DNA typing and DNA profiling, how does it help in investigation in the and also it is helpful in the medical malpractices. Then we have discussed about the witnesses, court procedures, then who can become an expert witness, what is the role of the doctor in the jurisprudence or in the giving the witnesses in the court of law. Then what is the disaster management, role of forensic person in the disaster management cases, how we can give our expert opinion as a medical practitioner and we can help the mass disaster management. And as it is mentioned, it is a multidisciplinary work and it is a team work which will help for the mass disasters. We have given discussed certain examples of the mass disasters, how the examination is happened in the regarding the body parts, issuing the death certificates, then how to discover the evidence, what could be the cause and how to manage disaster management and what is the role of the forensic medicine in the disaster management. Then how it is managed, there are 9 key ingredients by which we can manage do the disaster management. How to bring the disaster management condition under the control and how to contribute and do the identification, investigation in the accident itself. Adequate victim identification, professionally trained person, then interdisciplinary persons are involved in such cases. Now, we have discussed all these things under the role of forensic medicine. Thank you.